It is 1 o'clock, and I think we'll get started. Uh, a little bit different this week, and as you may have noticed, obviously, we have a guest on this week's webinar. Thank you so much, Bruce Young, for joining me. Just bear with me 1 second. I just want to take this the scrolling ticket off. And I will put my details up. So thank you so much, Bruce, for joining me today. So Bruce Young is the founder of a company called Collective Agreement. And the reason I thought it would be interesting to have Bruce on the call this week is to explore a little bit more about after the will has been written and after the person has died. That process and what is involved in dealing with an estate after the person has died and the family are all now working together to resolve the estate, and they have potentially have their eye on inheritances. So Bruce is an expert in this area. He's the founder of Collective Agreement. And I want to make sure that I introduce this correctly, because Bruce doesn't bill himself as a mediator. I think he would see himself, and maybe I could let you introduce yourself, Bruce, but facilitator, because family relationships can get difficult and complicated when inheritances are involved. And sometimes they need a steady hand and somebody that they can go to help make the process a little bit smoother, and particularly help with those dynamics between individuals who are involved in as an executor, as beneficiaries, or as loved ones who may potentially be grieving. So, Bruce, maybe if you could give like a 2-minute summary of Collective Agreement and where you see your important roles in the estate administration process.
Thank you, Tim. And first of all, thank you very much. I'm very honored to be here with you and to be a guest and to be talking to your audience. So thank you, and thank you for the opportunity.
You're welcome.
Hello to our audience. I am based in Toronto. I specialize in estates and trust work across Canada, although I being in Ontario, most of my work is in Ontario. Officially by title, I go as an estate and trust advisor. To put it in a different context for your audience, Tim, you and I are on two ends of the spectrum. Your role, very critical around estates, is planning, is getting the wills and other documents in place. My focus of my work is on the other end. What happens when the person dies, and that those wills and documents have to be implemented. So I'm there primarily to act to assist executors and beneficiaries in what happens in terms of managing and administrating the estate. I sometimes called in right from the very beginning, so I'll get involved in the probate filing process when probate filings are needed, and usually brought in throughout a process to be a co-pilot, is the way I like to word it, for the executors, and guide them and the family through the process.
So you're not necessarily just brought in when things go wrong. It could just be when people start the process and think, this is a little overwhelming. I've not done it before. I'm going to need some help.
Yes. And so I will, now that said, most of my clients come by referrals. They come from all across the industry, including financial advisors, accountants, banks. By the way, for everybody here, I am an accountant. I'm a CPA, CA, and have both been in the professional world, and I've been in business. So I have a business background, so where a lot of my practicality comes from. And I've returned to a professional practice. Collective Agreement is just my professional practice, focusing exclusively on estates. I will get referred to clients quite often, even by lawyers, because I have a fair bit of experience with litigation. I'm often brought in on dispute on estates and matters that are prone to or are in dispute. And I will often help in terms of getting organized and getting ultimately to some form of a settlement. Now, I act for whoever my client is, so I always say to people, I'm not a mediator because I'm going to help you win in mediation. So I have a bias, and we, mediation is only part of the process.
Okay, so let's start from step one. Somebody is going to name an executor in their will. Who can be an executor in somebody's will? Like, what are the different options available to somebody who's looking to name an executor? We know that they could name friend or family. We know that there is a thing called a professional executor. There are trust companies, there are banks, there are lawyers. What are the options for somebody?
Well, you want to dive into one of the toughest issues. Okay, let's go.
I'm thinking in terms of like somebody's looking to write their will and they're on the executor page and they're going to name the executor. First off, what are their options? I'm not necessarily asking for recommendations.
Absolutely. It is probably one of the most challenging issues for those facing writing a will. And it is the critical success factor in how an estate will get done. There's no easy answer on this one. We're going to go well beyond an hour once we start digging into these issues.
Yeah, you got 3 minutes.
No way, it doesn't work. Thank you. I'm going to backfill this and explain in a minute who's best suited. But I often say to clients, if I can distill it down to just one question, and it's an oversimplification, but it's to make the point. If to use an individual as an executor, which I strongly encourage, but we'll talk about the difference between that and a professional executor. The question you have to ask is, can that person be even-handed? I call it the even-handedness test. If you're going to typically name a family member, and they're also going to be a beneficiary, and they may have their own history with other beneficiaries, family members, can they act in a way, because that's their role as an executor, that's their fiduciary role, to be absolutely even-handed, not with a bias towards what benefits them or perhaps certain siblings and not others? Do you have the capacity to be even-handed? Now,
yeah. So I think there's obviously different family scenarios, right? Because I think using our service in a classic family situation, married with adult children, let's say, and I think a lot of people would say, by default, I think I'm going to name my spouse as my executor, and then I'm going to name my adult children. I don't want to favor one or the other. So let's make my adult children co-executors as a backup in case my spouse isn't able or willing to do it. So I think that seems to me to be a very common plan for people who use a service like ours.
It is. It's what I most commonly see when I'm trying to where I'm dealing with an estate. It's not always right. So let me unpack this one for a bit. So first of all, an overall general category, as you identified, you can either name an individual or you can name a professional, and there are different circumstances. Sometimes you may want to name a professional executor. Those are all the banks through their trust companies offer those services. You can go to lawyers who will do that. There are even a number of other services that will offer that. Nothing wrong with it. They're professionals. They've got lots of experience, but they charge the fees. The fees are expensive, and they tend to be, because of the very nature of the work, both impersonal, because they don't have that same connection, and they have a process that, because you're just one of many files, it can take a lot longer. So for estates the average person writing a will, particularly using, legal wills, I don't know that a professional executor is a prudent choice, because you're going to add layers of cost and time to it, unless you have a family situation that is dispute prone, or you have nobody that you feel that you can lean in on or trust to be your executors. I commonly see, it's becoming more and more common these days to see, people without children. I mean, we just assume, adult children, but the fact is a lot of people without adult. Who do you turn to? You've just emigrated to this country, or you've been here and you don't have your family here. Not everybody has that full network. So there are circumstances where it is hard to find somebody, and that's what the corporate executors can do for you.
Let's talk a little bit about, if I'm going to name a family member, an adult child. Let's talk at a high level. What kind of skills am I looking for from that individual?
Sure. I'm gonna come to that, but I want to go backwards one step here. Let's first go to the spouse. Should you name a spouse? Because what I'm about to talk about in terms of the skills applies equally to the spouse. That's why I'm picking that slide. Should you name your spouse? If you think your spouse can handle it. Should you name your adult one or some of your adult children? Sure, if they can handle the work. There are lots of articles out there you'll read there that will say, "Oh, being an executor was the worst thing in the world." My experience with executors is probably one of the most rewarding experiences. Not only do I see it with my clients, I've been through it personally. When you have that personal touch, that personal connection, it is actually an incredibly rewarding experience. So now to your question, what are the skills that are needed? It is less about the skills and it's more about the temperament and the personality. You can acquire skills. Don't understand tax? No worry. There's lots of people who can help you with tax. Don't understand how to do a probate filing? No worries. Lots of people can help you with that. If you've got real estate, we get a real estate agent and expert for you. The skills that are needed are often easily and readily available. Hopefully the will, by the way, has a clause that says the executor is empowered to hire those professionals and pay for it. And I know that's a clause that you have, Bill. It's a very important one, so that there's no dispute afterwards. So when I read lots of people say, "Oh, don't be an executor, you need all these different skills," I actually push back at that. I think what you have to be good at is you either have to be a good project manager, and if not, that's what you hire me for. So the role that I play more than anything else when I'm working with an executor is a project manager. I help them get everything organized. Oh, you don't have a real estate, there's a cottage, they want to sell it, don't have a real estate agent in wherever the cottage may be, boom, let's get it. Oh, wait, we've got a cottage in Quebec, how do we deal with Quebec situation, or et cetera. I've got a ski place in Kelowna. It's finding the right experts to help and to deal with and to find to deal with the assets and the debts that have to go with it. For me, the litmus test around how to pick an executor is around personality, and you can't assess that isolated to just the individual. You have to look at it in the context of the family dynamics. You have to look at it from the perspective of what's the nature of the family? Is it dispute prone? A lot of families are. Is it going to be difficult? Then is there somebody or some in that family that can that are better at navigating to keep to work through family issues as you're dealing with beneficiaries? Case in point, it's going to take. The average estate is going to take at least a year. We'll talk about it later. The executor's year, probably these days, with the way the courts are backed up, 2, maybe even 3 years. Yet you have family members who are waiting for their inheritance, and they're screaming and shouting, "Wait, I've got the kitchen rental guy waiting to go." And you have to have somebody who has to be able to communicate effectively with family members. Say, "Slow down. Here's the process." To be able to do that type of communication. So for me, it is around the personality of that person.
So you think the questions have been hard so far, but I'm going to ask you an even harder one now.
Throw it at
Um,
me.
what's the workload? What does it look like if I've been named as an executor? How much time is this going to take?
Man, your questions are loaded. So
I think I would answer if I was asking me that question. I would answer more than you think.
well, I'm
But
going to flip. I'm going to flip the answer on you, and I don't think you're expecting this answer. Um, it can take a lot less if you upfront the work. If you do proper planning, if you've got the right documents in place, if you've done the right steps for estate preparedness, please bookmark that. We're going to come back to estate preparedness. If you've done the heavy lifting beforehand, it can and ought to be relatively easy to manage.
okay, let's now then take a look at the main roles and responsibilities. Let's step through that, right? So, okay, the person's died, and I've been named as the executor. And this is a long. We actually at Legal Worlds we have a whole booklet checklist on what you need to do at what time. You know, within the first week, weeks 1 to 3, and all of that. So we do provide that at Legal Worlds, but let's go through it. And if you don't mind, if just say at a high level, the person's died in some way. What does this executor have to do?
First and foremost, and I tell this to my executors all the time, the first thing you do is stop, take a breath, and take time to grieve. And I say that intentionally because it's a very, very emotional period of time. And it's very hard to act effectively as an executor when you're also, your heart's being tugged at, when you've got emotional triggers. So take some time. There is usually, not always, usually nothing that is so pressing that can't wait. That you've got some time before you have to deal with things. Biggest thing usually I keep an eye on is when are the income tax filings due, because you want to try to not miss those filings. And quite frankly, even if you do, CRA is very, very generous with executors in terms of they'll give all sorts of relief. They're excellent that way.
I mean, so somebody's died here, right? So let's give us a chance, right?
Get a chance, and then let the system do a little bit. The funeral home, if you're using a funeral home, will generate the notifications that have to happen. That said, the probably step one is to sort of say, okay, where is everything? Have we got documents? Is everything organized? What was left for us? Do we know? Do we know where the will is? Do we know where all the documents are? Do we know where the person's assets are? Hopefully that's been organized ahead of time.
Okay, and this is what you were saying about you as an individual can do a lot of the work ahead of time by just having everything prepared,
including communicating with who's going to be your executor or executors, and including making sure that ideally you've tried to talk to family ahead of time so nobody's caught off guard, but at a minimum, the executors. I have some stat. I don't have it in front of me, but it is something. There was a research study that was done, and it is. I mean, we know 1 out of 2 Canadians don't have wills. That's a sort of a general stat. It's around sort of across the globe. It's true in the U.S. It's true in the U.K., etc. 1 out of 2 don't have wills. It's less as people get above their 50s. They tend to have more wills, but keeping it current every 3 to 5 years, less so. There are of people who have wills and have executors, there's some enormous stat, like 2/3 of executors say they never even knew they were an executor. They were never given the information ahead of time. So don't do this in silence is probably the key takeaway here is, and these are hard conversations to have. And there's a reason 1 out of 2 Canadians don't have wills. There's a psychological barrier here for people, and I get it and I understand it. And I want to talk about that in just 1 second. But once you do it, once you confront it, and whether you take it on yourself or get somebody to help you, somebody you trust, that could be your tax accountant, that could be your financial advisor, your insurance advisor, somebody who you know and trust who can help you with having those conversations with whomever in your family you need to have those conversations. Ideally, everybody, all your beneficiaries, but at a minimum with the executors. And then it's a matter of getting things organized.
And I think, just to interrupt a second, an executor, if you've named an executor in your will and you haven't told them, that person has every right to say,
Yep.
no, thanks, I don't want to do it, right? Like, move on to the next person.
And ideally you flesh that out ahead of time. And here's another interesting aspect you mentioned before. I didn't get a chance to come back to it. Should you have more than 1 executor? Should you have 2? Should you have 3? And there are pluses and minuses to that, but let me just lay out a practical. Here's something that I want people to be aware of: that when you have more than 1 executor, it becomes if you make them joint executors, everything has to be done jointly. That can become very difficult if those executors either aren't getting along, have their own issues in life, or live quite a distance apart. There's a legal filing process which requires signatures. You've got one sibling living in Halifax, you got another one living in Calgary, and you now have to get the same document. You got to get it signed, and things electronically are a lot easier these days, but it is a difficult, painful process. And when you are joint executors, everything has to be done jointly. Every bill has to be paid jointly. So what you can do is you build in a provision that says they're co-executors, or an executor is empowered to do certain transactions up to a certain dollar amount, or stick to 1 executor and make sure that executor knows they've got to communicate with everybody else. Here's the other one. Here's the other one to watch out for. When you have an executor who is not resident in Canada. Now, if they're resident in a Commonwealth country, what I'm about to say has some flexibility, but in a non-Commonwealth country, very common. Maybe it was to the States, a little less so these days, but other countries, you have a problem, because when you go to apply for probate and your executor is not resident in Canada or resident in a Commonwealth country, the court may ask you to post bond. It is an incredibly difficult, incredibly painful process. Okay, so how does that, where does that come to play? You write your will, you forget about it. It's been written 10, 15 years ago. Now that child that you've asked, or whomever, has moved away, you now have a problem, once it's time to deal with your estate. Or you have joint executors where you have two siblings, but one has moved to the States, but because it's 50-50, you still likely have a bond issue. And then you can go, then I see wills that have 3 estates and 3 executors, or always an odd number. And then there's the bit about majority rules. And I've seen it where you have 2 executors and the accountant. Those are levels of complexity that depend on the circumstances.
And that's invariably, that's a parent who doesn't want to favor one child over the other, right? So they want to say, you know what, I love you both equally. I'm going to make you both joint and co-executors to work together.
Yes, but the favoring happens in how the estate is divided, how the residual goes, and who gets what in advance. One might argue there's no favoring when you make both an executor. You can have one person be the executor. Everybody's still going to get, if you want everybody treated equally, they'll get treated equally.
Okay, so actually, let's talk a little bit about, so once the executor, there are things that you can do to prepare your estate. And I think one of the obvious ones that people often overlook is having an inventory of their assets written somewhere so that somebody has a chance of finding them. But can we talk a little bit about, once you're in the executive role and you're now gathering up the assets, what level of communication is going on between you and those beneficiaries who are all now waiting for their inheritances. How do you maintain that level of communication with everyone? And what are the legal and then the, let's say, moral
Oh, I
requirements
love how you
in that
frame that
situation?
question. Thank you. It's a great way to frame it. Now, I'll suggest what is legal. I just have to point out to the audience, I'm not a lawyer. I'm not giving legal
Oh,
advice.
me neither.
Please, nobody take legal advice. You must get legal advice from a lawyer. I'm not giving legal advice. I'm an accountant, but I don't specialize in income taxes. I know a lot about income taxes, but I'm also not giving income tax. Okay, that disclaimer is now out. Hopefully everybody's got it. Now, let's move forward with that. In Canada, and let's also distinguish something here because you've got a national audience. Estates, incapacity, which I'm hope we will talk about soon as well, that is a provincial jurisdiction. It's not a federal jurisdiction. So it's important to recognize there are differences across the provinces. You have to know what the requirements are in the province that the estate applies to. And the estate typically applies to the province where the person last resided. There are nuances when you have assets in another province, particularly real estate assets. Real property or real estate becomes the issue, and that's common. It's not, I know somebody in Toronto who has a vacation home in Kelowna. I do a lot of work out of Ottawa. It's very common to find people with properties in the Gatineaus and elsewhere in Quebec. So property becomes a bit of is an issue. But otherwise, wherever the person resided at death, a lot of people lived one place but then ultimately moved for retirement, those are the provincial rules that will apply. Now, common across the country, Quebec a bit different, civil law, so it's a bit different. Common across the country is, unlike other international jurisdictions, US in particular, unlike what we see in Hollywood, there is no reading of the will. There is no rights of the beneficiaries to have a say in how the estate is managed. The only party that can determine how the estate is managed are the executors. If the beneficiaries don't like it, they have rights to claim against it and start a lawsuit if they want, but they have no other rights. They have to be notified about their beneficial interests. They don't have the right to see the whole will.
That's an interesting point, right? So, okay, you will be told you're in the will. I'm working on it. That's all I need to tell you.
I will always talk about best practices. I encourage this with my clients as well. Best practices are to bring all the benefit to make sure as an executor, and I'll always tell this to an executor, communicate. First thing you're going to notify everybody. I'm the executor. Hey, you've got a beneficial interest. By the way, that may be more than just children. That's just as true if you've got people donating to charities. A charity has if you've made a charity as one of your residual, as a bequest or even as a residual, it's very common. Now that charity has an interest in the will. So you have to communicate with who you've got with who the beneficiaries are. And just to the point here, best practice of any executor is to be very forthcoming with communication. Hello, everybody. Okay, now we go. Here's what we know are the assets. Here's what I'm dealing. Here's what we expect the time to be, and provide regular reporting. And with technology these days, that's easy. That can be whether it's a Zoom meeting or it's an email, or you set up I use an app that easily provides that information. The executor will get ahead of any type of dispute if they are forthcoming in communication. If there's a takeaway here for anybody who is facing being an executor, please take that one point away. Communicate.
Okay, can I throw a little curveball there? Because you just mentioned it. How does it change the dynamic if there's a charity involved and they've been left 30% of the estate? Does the charity typically start to be a lot more hands-on in trying to know what's going on?
Oh yeah. So and it depends on the nature of the charity. I have that right now where I have an estate where there were no children. Everything was given spread across 6 different charities. But please, anybody writing a will, do not list multiple charities. Do not list multiple charities. Simply say, I leave it to my executor. Write a letter to your executor to tell them how to deal with charities, and do not put it in the will.
Wow, that is that's advice.
I may
Wow.
get
Okay.
slammed for that, particularly from some of the charities and the foundations that
This
may be
this
watching this,
this
or
is
they,
this is Bruce's
that's just my
opinion.
opinion only. But do that. And another thing that I know that I'm going way off on a tangent here. I'm a huge advocate of what is called a donor advised fund, a DAFT, a donor advised fund. If you are planning on giving, and listen, when we're dealing with people with wills in the later stage of their life, this is our stage of life of decumulation. We're giving away money at that. We're living off that money. We may be giving it away. We may be gifting it to children and loved ones, but we may also be doing greater donations. And it's typical to find donations in a will. Use a donor advised fund. It's a small fee to pay. You pay administration fee. They're fabulous. You give your money to one fund. It then distributes according to what your wishes are. You set out what your wishes are.
And so this could be a whole another webinar talking about donor advised funds, but this is something that you set up during your lifetime, right? And it's ongoing during your life, and then after you in your will you say, I want to give this portion of my estate to the fund that I've already set up.
There's a few of them around. There's a number of them around. They're basically like a fiduciary. You give them instructions. You put money to them. They're going to charge a management or a fee. It's like no different than money with the bank. The banks charge their fees, and they will distribute the money according to what your instructions are. You'll get one charitable receipt a year, not 20, not worrying about where all these different things. So even if you're doing small donations, you do it through your donor advised fund. You make your donor advised fund the beneficiary. It distributes the funds. It already has the relationship. It is so much easier.
Yeah, and you don't have to deal with the possibility that the charity is not running anymore, or it's changed its name, or things like that can happen.
That can happen, but the other part of it is when you and to your earlier question, when you name a charity as a beneficiary, they have a vested interest in how the estate has been managed, which is fine, except they themselves tend to be very, very large organizations, large structures, multiple layers. And we should be talking about what it's like sometimes to deal with the banks, but it can be very difficult. So, administratively, they're going to say, wait a minute, have we seen a statement of accounts? Now, all of a sudden, the executor has to produce a statement of accounts. Most people, it's not hard to do, but if you've never done one before, or if you go to an accountant or a bookkeeper who only does corporate work, 99% of the bookkeepers that you deal with out there, they won't understand a statement of accounts, in particular court format. So it depends on the charity. Some charities are fine. They don't make it difficult at all. They get this. Many charities are used to receiving bequests, and that they find a way to administratively make it much easier.
Yeah, I have certainly heard that charities, they're professionals in receiving money. And you could be an executor doing this for the first time. So there's a bit of a power imbalance there sometimes. And you can be overwhelmed.
If you are making if your intention is to make a significant bequest to a single or two charities, if that charity is a well-developed charity, they'll have a foundation office. Talk to them ahead of time as part of your planning. I'm jumping back to state preparedness, but there's a good example. Have the communication. I'm going to put you in the will. What is it? What do you need? What do we need to set up in place? How do we make it administratively easier? Have those conversations ahead of time.
So you mentioned one thing earlier, and I know we've gone 5 minutes over, but I have a couple of other points. You mentioned incapacity. You said it like you've used that word once. Now let's go there, because Are you also involved in the estate, conflicts in the event that somebody has become incapacitated?
I think we might need 3 seminars for this one. Okay, so let's put some borders on this thing. So incapacity is when at a point in time when you no longer have decision-making capacity. That is not an easy thing to determine, and it is not something that just is, and I want to be clear here, it is not something that just because you may have diminished capacity one day, or and you may not another time. Amongst lawyers, we'll often hear them talking, saying, when you did a capacity test, you do it in the morning or the evening, because people's cognitive abilities change. So this is about dealing with people with cognitive ability. The other general comment is we know our population we're all growing older. As a population, we're living longer. We also know that by the time we're 90, something like, what is it? If I remember my stats correctly on this one, 4 out of 10 Canadians, 40% of Canadians will have a serious cognitive decline, dementia or similar. So this is a very, very real problem that has to be dealt with. The other key point here is to understand that at a point in time when somebody no longer has decision-making capacity, there's no changing anything in their plans. So whatever will, whatever POA, whatever other arrangements, whatever beneficiary designations on the registered accounts and insurance, whatever they had done, that's it. Nobody can change it after that. So it's a very, very important part here. The other important part is, and it's actually why I push back, and I think, Tim, you've seen me post on, and when there's once a month, it's called Make a Will Month. And I always push back and I go, it's not just about the will. Estate planning is a will, and it's POAs, powers of attorney. And it's not just one. You have power of attorney over property. You can have multiple powers of attorney. You don't have to have just one over property. It's power of attorney over healthcare. Some provinces call healthcare directives. Again, it's a provincial jurisdiction. When you are talking about your estate planning, you must be talking about what happens when I no longer can make a decision, and how will my affairs be managed? Who's going to be able to write the checks to cover my expenses? I live in a condominium. Right. Our condominium, in order to be able to interact with the owner, you have to have the POA on file with them, etc. So incapacity planning is part of estate planning. It's a critical part. Now, interestingly enough, the person that you put in as your POA, or the people you put in as your POA, otherwise known essentially as your substitute decision maker, they're going to make decisions for you when you can't, is really the same function as the executor. So right. This is really a continuum. It's all part of the decision-making continuum. So that's why you do the two together. You must do a POA when you do your will, and you check them together. You make sure they're still current and they still make sense. And the function of that POA,
I often explain.
Sorry, go ahead.
Sorry, I often have to explain that to people, this idea that the power of attorney is, in effect, the moment you die, that document stops, the will comes into effect. Those documents can never be in effect at the same time, right? The moment you die, you cross over from one document to the next.
So it hands off. You go to the bank with that POA document, but you're saying, here's a death certificate, boom, stop, you're done. Right. But it's an important conversation. Earlier on, and I know we're blowing past the time here, but I got to do this. We were talking about estate planning, and 1 out of 2 Canadians don't have wills, and they struggle with it emotionally, psychologically. I was talking about it before, the difficulty of talking about it with families. I often say to people, if you're going to have a conversation with your parents, whether it's your parents talking with you or the adult child having the conversation with the parent, because that conversation goes both ways. It really should be circular. Or if we have advisors who are watching this, if you're a financial advisor, insurance advisor, accountant, whatever, the conversation to be had to in part break down that psychological barrier is say, let's open this up to, I know you don't want to talk about what happens at death. People have an aversion to talking about a death. let's talk about what happens when you are no longer capable to make your own decisions, physically, mentally. You don't have you don't have capacity. Oh, that I'll talk about. Sure, I want this, I want that. We got to prepare the house. I want to age at home. I want to age in a retirement retirement home, etc. People are usually much more open to that. And I'm not. This is going to open a whole kettle of fish, and I'm sorry to do this to you, but and that's where you have to have a conversation around joint bank accounts. So I'll leave that one.
Yeah, I think it's interesting. The one thing I would say is that the difference between preparing a power of attorney now, like doing it now and coming into effect if you lose capacity, compared to the people who come to us and say, my father has lost capacity and now I want to be a substitute decision maker, you've just made it 100 times more complicated than if that document had been written when the person had capacity.
We talk about this all the time, Tim. If somebody doesn't, those of us in the industry, somebody dies without a will, it's called dying intestate. It's much more difficult, and it is a very difficult process. Well, flip the coin. If somebody doesn't have a POA and now they're incapacitated, you need to go to the court to get a guardianship order. And I'll speak for Ontario and Ontario lawyers and Toronto and Ontario lawyers. $20,000 later, and about 8 months, you may get a guardianship order.
I didn't know that. Wow.
And it is,
okay, that's interesting.
It is so common. I had a client, aging mother. She had to move into a assisted living residence. Her home is now empty. The family's got to deal with the home. They can't. They don't have power of attorney. She's still alive and doing well, and hopefully will do well but she's no longer at home. We have an empty home. We have an empty house that we can't, it's difficult to, it's much more expensive to insure. We can't sell the house. Nothing can be done. So we had to go and apply to the court for a guardianship order so that we could deal with it. Even the property insurance company said, we can't deal with you because you don't have a POA. It is a critical piece of planning.
I think that, we could have, I'm going to wrap it up because I think we could have done more of these real life horror stories, because I think the message that comes out of this, we're all the time telling people to get these documents in place. And to your point, people don't, they procrastinate. I don't need to do it today. I can do it next month. I can do it in 6 months. It doesn't matter. There's no urgency to preparing these documents. And often people prepare them when they're faced with a situation that triggers them into preparing them. But I think that the message really is, you don't have to wait. If you do these documents, the will, the power of attorney, the healthcare directive, medical directive, if you get them all done today, it might take you, if you use a service like ours, it might take you an hour. The consequence of not having them is so colossal, and not for you. It doesn't make you, it's not going to change your situation. You're incapacitated, or actually it could if you're incapacitated, but if you've died, it really doesn't have any bearing on your situation. But if you care about anybody, if you care about your loved ones and your family, it's not that much work to set them up right, as opposed to leaving them with a complete mess.
I'm a big advocate for legal wills. So I'm about to advocate for legal wills. I do a lot of public speaking. For your audience, I do a lot of public speaking, and I do a lot of public speaking actually with lawyers. And they all say, "Oh no, lawyers should always write the will." And I go, "I'd rather have a will than no will at all." Here's the beauty of what is happening. Here's what's the beauty of what you pioneered. It is relatively easy to change a will. Some time on that computer, you can update your will. So the key message here is write your will sooner in life and change it as life goes along. When should you start writing a will? Probably when one of two things happen in life. Either you start when you accumulate assets, and or when you get married, have children. There's your first critical starting point for having a will. As life moves along and as it becomes more and more complicated, you change your will accordingly. I always say you should review a will annually. I always talk to accountants when they do tax returns to do that. But if nothing else, every 3 to 5 years, you should be looking and reviewing your will. That's not a difficult exercise. That is, a half an hour is everything's still the same. The executors have picked, do they still make sense? They still live here. Do I still want to keep the same beneficiaries, et cetera, et cetera? Have my assets changed? Have my debts changed? Are there things I could and should be doing differently? Every 3 to 5 years at a minimum, you have a look at that. And as life moves on, if it gets more complicated, maybe it's something you say, it's time for me I'll take my will and I'll go to a lawyer because I have really complex situations. But if nothing else, if you don't need that, you just constantly update your will to match what your circumstances are. And then as you reach a period of decumulation in life, again, your will's got to start reflecting that, as does your preparedness. Okay, so we know people don't usually start till they're 55, 60. We know the statistics. But in fact, they should be starting much earlier.
I think it's a really good message. I appreciate it. It's something that we spend our whole lives trying to tell people. And I think that one of the groups who come to us are people who have said, you know what, my father just died without a will, and I'm not going to put my family through what we've just been through. So once you've experienced it yourself, you say, that was a nightmare. I don't want to put anybody through that. So I think that's a really good message to end on. So Bruce, I really appreciate your time. Collective Agreement is your organization that people can reach out to if they're dealing with an estate that they need help with. I'm sure you're very able and willing to listen to people's situations, and you'll know whether you can help them or not. And there are some things that your wealth of expertise is going to set people straight very quickly, I think. So
thank you, Tim.
Yeah, I really appreciate your time, Bruce. I've learned some things on this call, so that's always great for me. Rather than me just talking on a webinar where I don't learn anything if I'm talking myself, I've absolutely learned some things from you. So I so appreciate your time, Bruce. And maybe we will do a follow-up because I don't think we covered everything.
Right. We're going to do one on an incapacity. That's a whole issue in itself. And we didn't even get into estate preparedness and the steps that I'd love to be able to have that conversation. One of the most common things I hear from people, how frustrated they are with the banks. Oh, but the banks are terrible. No, they don't have. I'm not trying to advocate for banks here, but they don't have to be if you prepare properly. There's so many critical steps of preparing that aren't difficult to do. Okay. But this is estate planning, estate and incapacity planning, so keep the two together, has to be done as a serious, purposeful exercise. Invest in it, get it done, constantly update it. Any major life changes, that's when you're going to make a change.
I think it's great to finish with there's a lot more, and maybe next time we can talk about practical steps for what people could do to help their loved ones and family. But in the meantime, we will do a follow-up. In the meantime, I thank you so much, Bruce, for joining me. I really have enjoyed it. So if anybody has any follow-up questions, they can get in touch with me or get in touch with Bruce, and we will be very happy to answer questions.
Thank you, Tim.